Okay, the November 14th meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force is now in session. First item.
Item number 1, call the roll. Member Highland.
Here.
Highland present. Member Moss.
Present.
Moss present. Chair Kanata.
Present.
Kanata present. We have a quorum. I am not aware of any agenda changes or communications at this time.
Okay, item 2.
Item number 2, approval of the September 12, 2016 Compliance and Amendments Committee meeting minutes.
Do we have any issues with the minutes?
Sorry, say that
Any
again?
issues with the minutes?
I did not see any this time.
Okay, public.
Would you like to make a motion before public comment?
I move to accept the minutes.
Second.
Okay, public comment on the minutes. Seeing none, public comments closed.
Would you like to adopt that without objection?
Yes. Okay.
Next on the agenda, item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Any public comment?
Members of Compliance Amendments, Ray Hartz, Director, San Francisco Open Government. As you know, because I say it endlessly, I've got 27 orders of determination related, issued by the task force, and I have only, through my own action, gotten compliance on any of them. The Ethics Commission repeatedly has taken complaints that I have been referred to them and decided either not to have a hearing, which is the predominant number of cases. They had one hearing where they were hearing the case when they themselves had been found in violation for the exact same thing they were hearing the case about, which I think is ethically questionable for the Ethics Commission especially. And then the last time they were so afraid of my being there that they held the hearing while I was out of the state. I had let everybody know that I was going to be out of the state from specific dates, so that anything that came up on an agenda I wouldn't miss. And they put out the agenda for the hearing to the referred complaint on the day I left the state and held the hearing the day before I got back. So it is really kind of anachronistic now. Given that, I will say that I have gotten all of the bodies that, say, for example, the 150-word summaries, all of the bodies that have been ordered to do so, with one exception, now put all the 150-word summaries in the minutes. And despite the fact that they came in and argued about the dire consequences, none of the commissions or boards have stopped working. There has been no legal problem identified by the city attorney's office or anybody else as to the presence of those summaries in the minutes. And as a result, I think that the First Amendment, the state constitution, and the Brown Act have been served well by the actions of this committee and also the full task force. When people come to a public meeting, it is free speech, and it is political free speech, and it is constitutionally protected political free speech. And the bottom line is that kind of speech rises to the highest level of scrutiny than any other form of speech. And so the 150-word summaries, although I've only gotten 2 of my compatriots to utilize it, now ensures that when a member of the public speaks before a board or commission of any kind, if they actually have something they want to say that is something that is contrary to what that board or commission wants in the record, it will now appear in the record. And that is an unfortunate thing because a lot of it comes down to the fact that if you're going to take the time and energy to appear before a board or commission, you want what you have to say to appear in the official record.
Thank you. Any other public comment? Seeing none, public comment is closed.
Next on the agenda is item number 4, file number 16053, hearing on the status of the order of termination. Complaint filed by Joe Igno against Officer Candy Hilder and the police department for violating Administrative Code Section 67.21 A, B, C, and E by failing to provide public records without unreasonable delay, failing to provide public records within 10 days, or justify withholding any records by demonstrating in writing as soon as possible and within 10 days following the receipt of a request that the record in question is exempt, failing to assist the requester in identifying the existence, form, and nature of any record or information maintained, or assist the requester in directing a request to the proper office or staff person. On August 3rd, 2016, the task force heard and referred the matter to the Compliance and Amendments Committee. It was requested that Officer Anderson, Officer Candy Hilder, and Lieutenant Whalen attend the meeting to explain why the requested records cannot be provided and to provide the requested record. In addition, please provide information as to the reason for the 1-month delay in responding to the records request. The record requested was on February 8, 2016 and February 25, 2016, and the denial of the request for records was not provided until March 29, 2016. I would like to let the committee know that the police department has provided the information to the requester. I do not believe that Ms. Inco is in the room. She was notified via mail, but I don't see her present in the room at this time.
Okay, so there is no complainant. Does the respondent have come up and have 3 minutes to give us the facts? So it seems like the information was provided. There was an email on the 8th of the month, but still the full task force asked the police department why this was not done in a timely fashion and following the ordinance.
This one is in your discretion. I believe it would be appropriate to ask them to write a 3-minute summary of a response.
Appropriate, you said?
Yes.
Yes. So
good afternoon, Lieutenant Walland, San Francisco Police Department Legal Division, and Officer Hilder.
So at the full task force meeting, the request is that you not only provide the information, but also let us know why it took longer than allowed in the Sunshine Ordinance to provide the information to the complainant.
So I'm not sure the reason for the initial delay. Our policy does require that reports be reviewed before being released, especially in cases that are assigned to particular units. I believe this case is assigned to or falls under Special Victims Unit. The requests do go through inter-office mail, and there probably was a time lag associated with that and the high volume of requests that we get through the record room, which is I think about 25 or 30,000 requests a year. So that's the reason, most likely for the initial delay. I don't have any paperwork or anything that I can nail down.
Okay.
You know, what exactly caused the delay. I have met with the captain and other sworn staff in the record room to try to get a system in place so that when we do have to send things out for approval for release by specialized units, that the requester receive, the notification that that's been done within the 10 days, and then, hopefully we can complete it, within the 14-day extension. So we're working towards that system.
Any questions?
Question for the clerk, Victor. I was not at the full task force meeting in August when this case was heard, so I'm playing catch up here a little bit. Am I to understand that the complainant, Mr. Ekno, has received all documents, and has he communicated that to you?
I did not receive that communication from the complainant. I did receive that from the police department, stating that the report was provided after the meeting occurred.
Okay.
That is in the packet.
Okay, and you sent notice to Mr. Ekno that this meeting will be held, and his presence is or is not required, and no response to that email?
I did not receive any response. This person only communicates via U.S. mail, and I did provide, at a minimum, I provide 2 weeks' notice via U.S. mail.
So that's the last communication Is
Was the
out-
notice of hearing outwards.
Okay, and what-
Notifying him of the hearing.
And what's the last communication you received from him? If you remember.
I'm not aware specifically, but he did show up at the full meeting, so
Okay. All right. Thank you.
So what are our options here? I mean, if he's gotten the information, do we need any motions, or is this just,
Well, I guess we can, through the chair, we could ask the respondent, let me ask you directly, Lieutenant Walland, have you provided everything that was part of the order determination, all information?
Yes.
Okay, and when was that provided?
It was provided on November 8th.
Okay. Just at a first glance, that seems like a very long time from August, when this case was heard and order determination was made. Can you explain why it took you 2 months? 3 months, I should say.
It wasn't communicated to me that we were to provide the documents. It was just communicated to me that we were going to come back at some point. And then when we received the notice and we reviewed it, I reviewed it and saw that we could release the documents. And so that's what I did. I didn't appear at that meeting. I wasn't able to appear at that meeting.
Okay.
So I didn't.
Perhaps I'm reading this wrong, but I thought, there's clearly some violations of timeliness back in August.
definitely?
And I'm sure the directive then was to provide this information as soon as possible.
Correct.
And that's why it would have been sent to the
That's why it was
compliance.
sent here, to make sure that happened.
And just curious, Mr. Clerk, why is it appearing at compliance 3 months later? Is there any reason that it's delayed, or was it just a lot of backlog of compliance? I'm just trying to gauge why there was a 3-month period before they actually provide information.
I believe that the last meeting of the Compliance Amendments Committee was canceled. I'm not.
just
I don't
not-
want to misstate, so I'm
Just
going to
not-
keep silent on this one.
Okay, I got it. So there's no particular reason that it just happens to take that long. Okay. Just my first thing would be, it's a bit worrying to me that the information was provided conveniently a week before this meeting. I mean, an order determination should be enough motivation for department to correct, the violations and work diligently to provide the information as soon as possible. I know a lot of the times the meetings, or these notices perhaps, get the departments to comply, but, with a department such as yours, which is, very active and very knowledgeable, as far as I know, on the Sunshine Ordinance, it just, worries me a little bit that it was only last week that this was, and this, again, is it your hearsay? We don't know from the complainant whether they actually received everything. So that's all my thoughts.
I don't really particularly have anything to add. So without the complainant here, we've got an answer, we've got the records, Was a copy of the records provided to us, Victor?
It was not.
Okay.
So do we have the records?
Well, we don't have the records, but presumably the complainant would have communicated. If Mr. Eckno contacts us later, are we able to pick it up again if we close it now?
Through the chair, I think we can refer this to the call of the chair, pending a communication from Mr. Ecknow, and seeing none in the future, you can then close it. I think that's an option. Is that correct?
I don't like to leave open-ended issues. We could find that the order determination was complied with the information we had, and leave the option open to reopen it if Ms. Inco communicates
Eckno,
that
yeah.
she is not satisfied with the response she received. I'll provide her a notice of the decision made by this task force.
Okay.
And if she decides that she wishes to reopen it, we can reconsider it.
And do we need any motions for that, or? is
Yes,
it-
we need a motion to that effect.
Okay. Any motions?
Motion to continue to call the chair?
Are you sure you want to continue it, or?
I think I do, because I'm still a little bit, we don't know if anything's been received. I don't like the fact that it was only last week that it was complied with. an order of determination should be enough motivation for that department to, and again,
I got a really feisty mic over here.
Good.
Did we ask about whether that was when it was complied with, or was that when we received the letter of compliance? Could we maybe get some
would you like
clarity?
to clarify that, Lieutenant Wallen?
What's the question?
When was the record provided to Mr. Eckno?
On November 8th.
Okay.
So
yeah.
it was via email. I just have a copy of the email, that says this attached as your record.
Right,
The
right.
record does contain personal information that should not be entered into the public record. It was released to him because he filed the report, but it's not normally a report that we would release in a public records request because of the information that it contains.
Yeah, so, is there a way, to me, continuing it just,
Sorry to interrupt, but just reading the original order of termination, violations of 6721 A, B, C, and E.
and then the next paragraph, Chair Wolf referred the matter to this
Right.
committee.
Explain why the record requested cannot be provided and/or et cetera, et cetera. In addition, please provide information regarding the month-long delay in responding to the record's request in the first place. I think at the very least, I'd like to see it continue just to make sure that the complainant does acknowledge by U.S. mail or however long it takes that he did receive, and I believe it is a he, everything that he requested.
Member Moss?
That's fine with me. I mean, did you make the motion?
Yeah, motion's made.
May I provide further clarification? In an effort to not bring it back if this Mr. Eckno is satisfied with the response, may I suggest something to the effect of continuing it to the college chair, and upon confirmation from Mr. Eckno that he is satisfied with the response, or,
Yeah, I'm fine with that.
and if I do not receive a response within so much time, is there anything you want me to do?
I think, again, let the chair make that call, but maybe you can...
I think if we let Mr. Eckno know that that we've been told that he has gotten his information, and to please verify, and that if we don't hear from him, we're going to close it. I think he has to take some part in
Okay,
it.
I have that. Thank you.
So,
So the motion is to continue to the call of the chair as amended by the clerk.
I second the motion.
Okay. Any public comment?
Hold on, let me get that.
Ray Hartz, Director, San Francisco Open Government. I want to clarify something that I think may have been missed. The lieutenant just held up an email and said that was the reply. The reply was sent by email, and yet we just heard testimony that Mr. Eckno does not do anything by email, and therefore the question is, number one, was the information sent to him via U.S. mail, which is, from our understanding so far, at least mine, is the only way he gets such information. And if not, then there's really technically no response. So, and again, the answer to the question that was critical in the full hearing of the task force was that why did it take so long? And the lieutenant has just testified that she doesn't really know because she didn't talk to certain people. And so we still don't have an answer to that question. I have a long history with the police department trying to get public records, and unfortunately have found that there are all sorts of challenges to do so. Most recently, I made a public comment at the Library Commission meeting, and the Library Commission president went to the police department and filed a complaint against me, saying that I had threatened her. When I tried to get the documents to actually see what she had written, they held on to them for over a year, saying that the investigation was still open. And unfortunately, with the incidents we were talking about, which is filing a false police report, the statute of limitations, is my understanding, or it was explained to me, as a year. So it was basically, okay, we're going to hold this investigation open for a year, and then by the time you actually get the copy, you can no longer act in a way that is appropriate, given that my position was that the police report was a false report. I had used a historical analogy referring to ancient Rome, and she said I threatened to kill her. Now, the most interesting thing about this was later on the Library Commission's website, there was a recording of the meeting, and it was allowed to continue past the end of the meeting. And the Library Commission president, Jewel Gomez, was quoted as saying, "I know, Mr. Hartz, I knew 12 people who could fucking bury him," and made other comments which actually got into the newspaper. So in that particular case, it was not me threatening her. She was actually recorded, and it was published on the city's website, the Library Commission's website, that she was threatening me, saying she knew 12 people who could bury me. So I think it needs to be left open for the simple fact that, number one, we don't know if Mr. Eckno got the documents, if they were even sent to him in the way that he has said he gets information, and we still don't have an answer as to why it took 3 months.
Any other public comment?
Through the chair, could we ask them if they mailed it, if they mailed the information?
Yeah.
Lieutenant Wallen, would you approach again? Thank you. So I guess the question is, our clerk knows that he only deals with U.S. mail. Were you guys aware of that?
Well, we had one of the things that we sent to him returned as undeliverable because of the address he provided, and so that is why we contacted him through email and provided it to him email, so we could confirm that he was getting it. So that's why it was provided via email. And he may communicate only with this body, but via email, but he did have communication with our records management, crime information services division, who provided the report to him through email.
So he has communicated with you guys through email, is what
Yes.
you're saying? Okay.
And this email did not bounce back?
No.
And did he get back to you after receiving this particular email of the 8th?
It was released through our record room. So
that a no?
I did not get any notification that he did not receive it or that had bounced back.
Okay.
Is that like a no reply email, or
No,
Could
it was
he-
sent by a supervisor.
so he could respond to
Yes.
that, saying thank you, I
Yes.
got it, and has he ever sent you an email?
I've never communicated with him, no.
So you've sent him emails, but you never know.
I have never personally communicated with
department.
him.
Your department.
I can't speak to the other people in the department. I do know that one of the supervisors of the record room made contact with him, and I think she asked him how he wanted to receive it because we had an item returned from
Okay.
the building that he wanted the mail sent to, so we wanted to make sure they actually got it and it wasn't returned,
All right, Mr. Clerk, have you received emails from him?
I have not myself.
Oh, so it's only been.
He has not provided email address to me.
Okay, all right. Interesting. So it sounds like they have been trying to provide information.
Yeah, I mean, when we took I guess Officer Hilder just brought to my attention, when we took the report, he did provide an email address to us, and so that may be, how we initiated that particular contact. So,
Yeah, I'm fine with the motion as it is.
Okay, thank you.
Thank you.
On the motion, is there any, we just
We have
received public comment on the motion. Is there any further public comment on that motion? There being none on that motion, Member Highland.
Aye.
Highland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. The motion passes. I will keep the parties informed as we progress with the communications.
And through the chair, if you could let us know if you hear from him saying receive, thank you very much, any indication like that, please forward that to our clerk. Thank you. Appreciate your time.
Okay. Next item.
Next on the agenda is item Number 5, file number 16063, hearing on the status of the order of termination. Complaint filed by Michael Petrellis against Supervisor Scott Wiener, Board of Supervisors, for allegedly violating Administrative Code, Section 67.25A, by failing to respond to an immediate disclosure request in a timely and/or complete manner. On October 5th, 2016, the task force heard and referred the matter to the Compliance and Amendments Committee. It was requested that the respondent provide the remainder of the requested records and/or provide an estimate of the time needed to comply with the remainder of the public records request. It does not appear that either party is in the room at this time. I have not received any communications from either party.
Okay. So this is the same issue. We don't know if anything happened, and nobody's here. Do we, I mean,
Through the chair, usually Mr. Petrellis is pretty communicative. Nothing from him saying.
I have not received anything. I was going to suggest I can send a communication to Mr. Petrellis asking if he has received the remainder of the documents and how he wishes to proceed, and if he's satisfied.
Motion to put to the call of the chair pending any response from complainant rather.
yeah, I think we could handle this the same way we did the previous one, where we can have a motion to close it and contact Mr. Petrellis. Close it if we, after contacting Mr. Petrellis, if he tells us that he has all the information that he requested.
Sorry, I just have a question. So, Supervisor Wiener probably will not be with the city and county of San Francisco very much longer, and probably not until the next Compliance and Amendment Committee. So, in those cases, Member Highland, you've been here pretty long. What happens in those cases where we have a change?
We would still, handle the motion, and then if it came back, we would have to address it to the new supervisor, for that information. Or Mr. Petrellis would have to file again. But that shouldn't concern us. We should just go about our business as normal. And
I just didn't want to put something out there that there's not going to be staff to respond to us at some
right,
point.
that's why I've got a feeling that the complainant's probably going to let this drop. But at least let's give him the opportunity to communicate one more time. He does have email, so that's encouraging at least.
So I believe the motion is to continue the matter to the call of the chair, and I will write a communication to the complainant and inquire as to the status and whether or not he wishes to continue with the complaint. And if we do not receive a response from Mr. Petrellis, we will table the matter.
Right. And if we do and he says he has received it, we'll close it.
Yes, he can withdraw this complaint.
As amended.
And I second.
Okay, public comment, please. Seeing no public comment, let's vote.
On the motion, Member Highland.
Aye.
Highland, aye. Member Moss.
Aye.
Moss, aye. Chair Canada.
Aye.
Canada, aye. The motion passes. Exactly 4:30.
That's a first.
Just before we get into this, this is the first implementation of our new complaint procedure. I believe that the committee will be reviewing this matter and evaluating the issues and referring it to the full task force with or without a recommendation, and they will conduct a full hearing on the matter. That's the simple format. I have revised the hearing procedure for this matter. You can change it at this time if you believe it's not correct. Basically, I changed the speaking time from 5 minutes down to 3. It is listed on the back of the agenda. However, since this is the first time, I would suggest it more than able to change it if you believe they need more time. And not to influence you on this matter, there is the issue today for your consideration in that the two complaints are regarding a similar type of complaint for different dates. And I don't know if you would, how you would like to handle that. So that's for your consideration.
Yeah,
I would like to read the items at this time.
okay.
The first one is item number 6, file number 16088, complaint filed by Ray Hart against Angela Calvillo, Clerk of the Board of San Francisco for allegedly violating Administrative Code Section 67.16 by failing to place a written summary of the public comment if no more than 150 words in the minutes for the September 6, 2016 meeting. And I don't know if you want me to read the second one or not.
Read the second one, and this way we,
Item number 7, file number 16089, complaint filed by Ray Hartz against Angela Calvillo, Clerk of the Board of San Francisco, Clerk of the Board of Supervisors, for allegedly violating Administrative Code Section 67.16 and 67.34 by willfully failing to place a written summary of public comment if no more than 150 words in the minutes for the September 20th, 2016 meeting. If you would just like to take determination of jurisdiction on both items first, and then we can go into discussion.
So before we do that, I have a feeling that Mr. Hart has spent a lot of time figuring out exactly what he's going to say for every opportunity that he can say it. And I would hate to deprive him of that because he has made such noise about it before. So I would say that we should probably just find jurisdiction on the one and then hear them both separately. That's my thought.
Unless Mr. Harps objects to that.
Ray Hartz, Director, San Francisco Open Government. The reason I filed separate complaints was that there were two actual violations, and in previous matters before the task force, Chair Wolf has raised the issue of timeliness. The clerk of the board has been found in 2012 to be in violation, has not followed for the last 4 years the guidance of the task force, and therefore I didn't want to have it be an issue when we get to the issue of willful violation, it to be a case of, oh, you're trying to bring up this 4-year-old case.
Thank you, Mr. Hartz. Okay, so I think we'll, as Member Moss suggested, let's treat them separately. I will just say for the members of the task force, one of the new, or I guess one of the practices that we adopted in the past when we did decide in advance to hear items together was to try and notify that on the agenda to give both the respondent and complainant an idea that's going to happen. That hasn't really happened here, so I think we should hear them individually and carry on.
And maybe you can make that decision upon sending it to the full task force on whether or not you want the full task force to hear them together or separately.
That's reasonable, yeah.
okay. So,
jurisdiction on the first?
right,
So moved?
Second.
public comment on jurisdiction? Seeing none?
Would you like to pass that without objection?
Yes, please.
At this time, the way I have written it, the complainant is allowed 3 minutes. Would you like, is that enough time, or would you like to request the additional time?
Mr. Hart, is the respondent here? Yes. Okay.
And just to be clear, we're on 16088. That's the one we're on?
8-8, yes.
Right. So, Mr. Hart's 3 minutes good, or?
I think 3 minutes.
Okay. Fine. Okay.
All right, this is an issue that's been going on for the last 6 years. The first order of determination was issued in 2010. Following, there have now been 7 orders of determination, 3 against the Public Library, 2 against the Ethics Commission, and 1 against the Clerk of the Board. In addition, there was a violation found against the City Attorney's Office for acting as counsel in advising people not to put the 150-word summaries in the minutes. So there is quite a bit of precedence here. In addition, the task force, the chair of the task force, under the direction of the chair, sent out a memo to all city agencies, departments, boards, and commissions saying in the minutes means in the minutes. And every single body that was either brought here to the task force and found in violation or has gotten my 150-word summaries now places them in the minutes. One of the arguments that Ms. Calvillo makes in her response to the complaint is the fact that the Ethics Commission said that there was no violation, but the fact of the matter is the Ethics Commission itself now places the 150-word summaries in the minutes. And it's kind of idiotic to say, well, they didn't find a violation. I think it's kind of idiotic to say to the task force, the Ethics Commission said you were wrong. I just think as a matter of common sense, it really isn't the kind of thing you want to raise with a body who's decided something 7 times. And following the finding against the city attorney's office, a very long letter was sent, again at the direction of the task force by the chair, Hope Johnson, to the city attorney's office explaining all the rationale behind these decisions. And there is one issue that she raised, which I really do want to just bring up. It goes as follows. The task force notes other commissions have placed a disclaimer on the attached summaries that the summaries are not subject to approval or verification of accuracy by the commission. This may be perceived as placing an unwarranted negative bias on the summaries, and it is a further erosion of the public's rights guaranteed by the Sunshine Ordinance that is condoned by your interpretation, and your being the city attorney's office. So it's been ruled 7 times. Everybody except the clerk of the board has complied. No matter what the ins and outs are, they all predicted dire consequences if they were to do this. None of that has come to effect. And basically, as I've said before, I have from the very beginning said this is constitutionally protected free speech. It rises to the highest level of protection, and I submit to you that that protection includes being accurately represented in the minutes official record of any meeting.
Thank you. The respondent.
Hi, good afternoon. Wilson Ng, Records Manager for the Office of the Clerk of the Board. So in September, our office actually comprehensively provided a response to complaint numbers 16088 and 16089, which I'll both address here, but my later talking points will be the exact same thing. I'd like to point out that these complaints are identical, with the exception of the dates, identical to file numbers 13054, 13055, 13059 that was filed by the complainant back in 2013, which we also responded in November 2013, and the SOTF considered and resolved. That's also contained in the agenda packet that you guys have before you. So this same matter was actually heard in April 2014 at the task force meeting, where the task force, along with input by your city attorney, weighing in public comments, supported our office and determined that there were no violations, and you guys concluded the matter, which we appreciated. And here we are again. So Mr. Hartz, the complainant, submitted these identical complaints again. And as he mentioned earlier, he also submitted these identical complaints to the Library Commission and Luis Herrera, which the SOTF referred to the Ethics Commission. The Ethics Commission found no violation of both of these also, and stated, and I quote, "The minutes are paginated as a single document, including the addendum, and the task force cannot add or imply the words, quote, in the body of the minutes into the Sunshine Ordinance." In a duplicative complaint to the Library Commission's, Ethics Commission again motioned that no violation occurred and concluded that placing the summaries in the addendum that is part of the same document satisfies the requirements of the Administrative Code. Furthermore, the Brown Act imposes no additional requirements on policy bodies regarding what's recorded within the minutes. What we actually follow is rule of law, not what other departments do or what other precedents set. And the Admin Code 67.16 states that the clerk of the board shall record minutes for each meeting, specifically the time, names, titles of attendees, roll call vote, and list of public speakers. And the clerk complies by taking copious amount of notes as far as who the public speakers are and what their comments are. Now, if the speaker submits a 150-word summary, it's noted in the text next to their name as the reader is referred to the appendix. The reason for that is because the minutes must clearly reflect what's part of the record as part of the proceeding. And because those 150-word summaries that are submitted by members of the public cannot be validated by the clerk of the board, those statements must be in the appendices after the clerk of the board's signature, because she cannot validate those statements, those 150-word statements that are made, because those are not her own, nor are they part of the actual proceedings. So this matter has been addressed and resolved on several occasions, upheld by the task force, upheld by the Ethics Commission, and we believe that we conform to all of the said requirements. The complainant is more than welcome to disagree, but I do believe that there's a precedent set and it should be upheld.
Thank you. members.
So this is something I wish we had DCA Cola with us for, and I don't feel like I have enough guidance from his memo to really fully understand the complications here. It seems like there is some disagreement between the Ethics Commission and the Sunshine Task Force, between the Sunshine Task Force and the City Attorney's Office, and perhaps some inconsistency within the Sunshine Ordinance Task Force itself. Member Highland, were you here when this came up the previous time? Do you think you could, because I was going through the minutes from when this came up, and it seemed like there was a whole slew of motions and retracted motions and more retracted motions. So it was hard to follow what the actual discourse was like.
Yes. So this was, as Mr. Hart said, back in 2013. I seem to remember we tangled about where the 150 words should go. I think we felt in spirit it should go right after when that person stepped up and made public comment. It should follow that, just to clarify what the person said, and that's the whole point of it, rather than being buried in the footnotes at the end of the document 50 pages later, et cetera, et cetera. Now, whether, and I have to go back and read the original order of determination, perhaps we can get the two parties here to help us get back to that, but I'm not sure if we decided, in fact, we may have decided that that's the way it should be, but I seem to remember that the Board of Supervisors decided they were entitled to their own interpretation of that. I think that's kind of how it ended.
There was, on one occasion, the task force did find that there was no violation in this matter against the clerk of the board.
Which item was that? Or can you give me the...
This was approximately 2.5 years ago.
Yeah. Mr. Ng, if you could approach. You were referencing, and if you can give us the page number in our package, I don't know if...
I don't have the packet numbers in front of me, but it's from the April 2nd, 2014 meeting minutes.
I've got that. It's page 126.
Thank you.
And then it's 126, and it just goes and goes and goes and goes and goes and goes and goes.
Mm-hmm.
May I?
Just 1 second. Let's just catch up on this.
So, as I understand it, though, that it wasn't so much, based on my reading of Agenda Item 2 in that minutes, it wasn't so much that there was a vote to find no violation. It's just that there was no motion to find violation, if I'm understanding correctly.
Okay. I'm looking at it right now.
That was the past practice. We have, as of the last meeting, changed that practice.
So now you can
make a motion to find no violation. In the past, there would be just no motion made, and the issue would die.
Right.
But when there is no motion to find a violation, that doesn't necessarily mean it's like an acquittal versus a jury finding of not guilty.
Correct.
Right?
And they're also, just reading through this packet, there seem to have been a lot of instances where the full body did find violation for this same cause, for not including the summaries.
It's gone both directions by
Right.
this body.
Yes, and to me, it seems like at any given point in time, the interpretation of the statute in the minutes has meant different things.
Yes.
One
It
second, Mr.
might be suggested that we've been talking, the task force has been talking about writing a set of precedents for the task force. Maybe this is one of those cases where we send it up to the task force and suggest that they do research the issue and set a precedence.
And we have not retracted the May 18th, 2012 memo. We've not issued, is that correct? Have we?
I'm not aware of it.
So you're not aware of anything that we have put out changing the Sunshine Task Force recommendation, or our interpretation? It's probably the better word for it.
Well, in the packets I've seen, I have not seen, in this packet, I have not seen a retraction of that. So, yeah, I mean, I think it would have been nice to have DCA Cola here, and
Maybe we can, since this is our opportunity to review the matter and bring up issues to the full task force, maybe there are certain questions you would like to ask and have them bring up at the full task
Yeah,
force meeting.
I have a question for the respondent. You had stated that one of the reasons why the 150-word summaries or an addendum instead of in the minutes was that the clerk could not verify them. But these meetings are recorded. There's audio as to what each person said.
Right.
So actually,
Mr. Khanna, the 150-word is not specific to what they say. It is what they submit after the meeting.
I'd like to object to Mr. Young participating.
I'll be glad to speak, directly.
Okay, so let me see if I understand. When a person gets up and does public comment, they also can hand in a summary that theoretically doesn't have to be what was said during public comment.
Correct.
Okay.
So the 150-word summary is a written summary. Public comment is public comment that they speak, go up to the podium and
Correct.
speak. And that's, so there may be inconsistencies in what's actually happening in the proceeding versus what's actually submitted 150 words later. And that those documents that are submitted after the fact, after the gavel down, after her signature on the minutes, those are statements that can't be validated. Now, as far as whether it's within the minutes and falls within the guidelines of Admin Code 67.16, absolutely, because they are paginated as one single document, and right next to their name, there is a reference to the appendix. Should they want to go down to the appendix and read the 150-word statement as it pertains to that person's name.
Thank you.
Yeah.
Through the chair, I also seem to remember, Mr. Ng, if you could stay there a second. I thought there was like a disclaimer that Angela Cavillo would put there saying that, starting with the 150-word summary saying this is public comment as handed to us, we're not responsible for this. Is there like a kind of boilerplate sort of clause that she would use for that?
138.
Thank you.
Yeah, I can't speak to what the whether there's boilerplate language or not without reviewing the actual minutes, which I don't have in front of me.
Here it is. I see it. The following information provided by speakers pursuant to Administrative Code Section 6716. The content is neither generated nor subject to approval or verification of accuracy by the clerk of the Board of Supervisors.
That sounds about right.
And I think I remember taking the position, colleagues, that could appear before, the 150-word summaries, and yet they could still appear chronologically where they should. I mean, it was a question of the spirit of the law and the letter of the law. Mm-hmm. And I think my recollection was basically that we felt on the task force that this should be included, and this is what the Sunshine Ordinance is all about. However, I think the city attorney and the clerk of the board argued otherwise. Now, for the purpose of this meeting, I think what we're trying to do is just get oranges to oranges so we can get this up. The full task force, we've already found jurisdiction. I think what I'd like to see at the full meeting is I definitely want to see the orders of determination, and perhaps if Mr. Hartz could provide that chronology that you showed for us to the clerk. Victor, if you could, Victor, you want to grab that? Thank you. If you could just pull up those that case law, if you like, for us, just give us a short summary of that, of the order of determination in the packet for the full task force. I think that'll be good reading for the rest of the members, just to be able to validate that this actually happened and there is some precedent, et cetera, et cetera.
May I make a comment about what was just said?
Mr. Hartz, go ahead.
At no time in the last 6 years has the city attorney issued a legal opinion in any way, shape, manner, or form regarding this issue. They are repeatedly referring to the Good Government Guide, which is not the law. The task force has ruled 7 times that the law says in the minutes, and that means in the body of the minutes. Every other city body, the Ethics Commission, the Library Commission, the Police Commission, the Arts Commission, and several others, place the 150-word summaries, and there is no reason that has been provided by the clerk of the board. In fact, it's not clear whether she has ever, this has never been discussed with the board. This is simply the clerk of the board saying, I won't do it. And the bottom line is there is nothing in placing that 150-word summary that in any way interferes with her ability to do her job.
Thank you. Just for the record, I didn't say that the city attorney ruled. I just said that they provided background. Mr. Ng, did you want to respond to that?
Yeah, I didn't want to respond. Actually, I wanted to add to the document that that Mr. Hartz just submitted. I just wanted to ensure that file numbers 13054, 13055.
A little bit slower, please.
13054, 13055, 13059 are included on that list, as well as the Ethics Commission motions, whenever you're ready. 1302-251.
1302-521.
1302-251. And Ethics Commission motion 1306-2402. Both motions where the Ethics Commission unanimously passed that there was no violation. And the complaints were identical to what we have before us today, with the exception of the dates.
Through the chair, Mr. Ng, those were Ethics Commission's motions that we sent up to them.
Yes, that's
Okay.
correct.
And we have some of that in the packet.
Right, that we found violations,
Right.
and they disagreed. So all that should be part of the homework and the reading.
Correct.
I think that should be enough
Yeah,
homework for.
right. I mean, I think this deserves a full board meeting. I don't,
But everything is a full board meeting right now.
Yes.
no, right, it's a full board meeting. I don't know if we can have a recommendation because of to me, the ambiguity that has run through all of this.
I would say in the summary of the case, you could say that this has been ruled on in the past. We have found violations, which we've sent up to Ethics Commission, which has subsequently been.
Can we call some order or something?
Mr. Hartz,
I'm having
Mr.
trouble.
Hartz, sorry.
Gentlemen,
No, we're trying to talk here, so if you guys can sit apart, we have to make you sit on the. There you go. So it's gone all the way up to the Ethics Commission. We've had 2 cases. You can reference them, list of decisions, and also list that we have, I think, found in some cases no violation on the same issue, just to show both sides of where we've been. And I think lastly, Mr. Hartz's chronology of the fact that many other departments have been found in violation and have since complied, I think is an interesting piece of background as well. So I think those 3 pieces
right.
would probably be a good summary to kind of push this up.
Any,
So what does a motion look like here for just sending it on to the
I
the
believe
task
this
force?
time it'll be referred to the full task force for hearing, and then I will provide a copy, a summary of what Mr. Hartz just stated.
So is a motion required here, or does it just automatically go to the full task force?
We would still need a motion to take action to refer it up.
So it would be-
because there's always the possibility that you're not ready to send it up and you would continue it to a
Right.
future meeting.
I mean, I'll move to send this to the full task force.
and is that motion without recommendation? Does that have to be stated?
As long as you say there's no recommendation,
I'll move with no recommendation to send this to the full task force.
Right. So we could do it that way, or we could do it and recommend some of the violations that were identified in the item if we wanted to. So either way.
I think I've just as well let the full task force decide.
Okay.
So my motion will stay as stated.
Okay. I'll second that.
And we have there's no public here other than the complainant and the respondent, so there's no public comment.
would you like to allow them rebuttals?
Yeah, sure. The respondent first.
Complainant
You can
response.
come up, 3-minute rebuttal.
Oh, I'm not going to need the entire 3 minutes. I just wanted to recommend that you seek administrative remedy through the Ethics Commission or the City Attorney's Office. That's
Sorry, seek what?
Seek administrative remedy through the Ethics Commission or consult with the City Attorney's Office, because I feel like this matter has been discussed exhaustively, and there's been determinations on both sides of the fence, and I really do believe that there needs to be a third party or an attorney present in order to make a determination. Otherwise, we'll be running into the exact same scenario next time we come across each other.
Please list that as their position.
Thank you. Mr. Hartz?
Administrative remedy, I like that.
Fact. The task force, full task force, has ruled 7 times to find violation in this very issue. They have issued an order or advice to all departments stating that fact. They have sent a letter to the city attorney stating that fact. And they have had yet nothing from the city attorney's office. The only thing we have is my rights under the law, which this task force has ruled 7 times were violated by not placing it, versus the good government guide, which is not the law. And the bottom line is the only reason they want to keep these 150-word summaries out of the minutes is for, I believe, 2 reasons. Number one is that at some point in time, through an administrative method, they can simply say, oh, we're going to remove all attachments and addenda from the minutes, effectively silencing and removing my public comment. And the second thing is the clerk of the board does not want the public to be able to have what they actually say in the minutes, in the official record. If you look at the minutes of the Board of Supervisors, she does not, in many cases, even meet the minimum required by the law, which is to state who the person is, what they spoke about, and what their position was. She, in most cases, I'd say 85% of the cases, simply puts down a name and that they spoke, sometimes saying spoke on various subjects or spoke on just a 2-word summary. So basically, it is they do not want negative comments in the official record. That was the reason the Library Commission fought so hard to keep them out. It's the reason the Ethics Commission, and I said it was questionable when they had the hearings, and they were ruling on this very issue, and they were in violation themselves. I think ethically that's kind of questionable. And the bottom line is they have all complied, with the exception of the clerk of the board. And again, I will ask you to put into the record that there is a serious question as to about whether or not this has ever been discussed with the Board of Supervisors. It has never been discussed at a public meeting. And therefore, I think this is Ms. Calvillo simply making a decision on her own and now trying to defend it. She abridges, censors, misrepresents, and mischaracterizes public comment at the Board of Supervisors meeting. And the public has no option but to sit back and let it happen. And I would submit also that the letter and the guidance from this task force to all city departments has not been rescinded, and it is in effect. And if you were to, I'm really kind of shocked that you aren't recommending a violation on this, because it is clearly a violation of your own directive.
Thank you.
There being no members of the public on that motion, Member Hyland.
Aye.
Hyland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. Moving on to file number 16089. On the motion to find jurisdiction, is there a motion?
I'll move for jurisdiction.
Second.
There are no members of the public in the room at this time. Would you like to accept that motion without objection?
Please. Okay.
Mr. Hartz? would
Mr.
you-
Hartz.
All right, this is 7. Is that right?
This is item number 7.
Obviously, we're talking about the same set of facts, except this complaint was also for a willful violation. Every single agency that has been found in violation, the Ethics Commission, the Library Commission, so forth, has complied, and you do not see me filing any sort of a complaint against them. There has been absolutely no problem that has been identified. The city attorney, as I've said before, has never issued a legal opinion, although he's had 6 years and was himself found in violation. He has never done anything to counteract that. Now, I would submit that it is because he understands that what I'm arguing, which is this is constitutionally protected political free speech, is in fact correct. I think if he had a legal basis, he would have issued a memo sometime in the last 6 years. And Mr. Ng comes up and bemoans the fact we've been back here again and again, and I would like to point out in those cases he mentioned, there was not a finding of no violation, there was simply not a finding of violation. And everybody here knows the long tortured history of the task force where members were not appointed, seats were vacant, and then often cases we had to come in here and we'd have 6 members or 8 members and you'd have to get 6 out of 8 or 6 out of 7 or even in some cases 6 out of 6 votes to prevail. So not getting a finding isn't an indication of not guilty. It's simply as far as I can see, it's more of a mistrial than anything else. The full task force, I mean, I don't know what I can say. If you're not going to stand by the precedents that are set by the task force, especially in a case like this where a clear directive has been sent out to all city agencies and a letter has been written to the city attorney who had every option for 4 years to respond with any sort of a legal argument. I don't mean pointing to the good government guide and simply saying, well, that's what it says, because even the prefacing statement, which was written in the letter to the city attorney, is prejudicial. It basically, I think if you gave it to most people and let them read it, they would say, you know, what would that make you think about what you're about to read in the 150-word summary? So, lastly, one of the arguments that keeps coming up, although it's sort of under the radar, is the fact that there's absolutely no difference between putting it in the minutes and putting it as an addendum. If that's the case, then there shouldn't be any problem no matter where it goes. And since it does matter to me and to the public where it goes, it should go in the minutes so that they can't censor it, they can't abridge it. And again, Ms. Calvillo has, at my understanding, never had a discussion with the Board of Supervisors regarding this matter. This is solely her own take on the matter.
Thank you. Sir?
I don't really have anything additional to add in addition to what I stated for the previous complaint number 16088, same exact comments. I guess I just want to bring to your attention the meeting minutes from April 2nd, which specifically state that there's no violations found. And that's all I pretty much have to say. I mean, anywhere else there should be a presumption of innocence from the person responding. And in this case, there was no motion, or there was no real motion to find violation that was passed, and that matter was supposed to be concluded. No matter what the SOTF determines at the next session, we do want to avoid having to come back here over the same matter because it does take a lot of staff resources for us to not only address these complaints, to respond to these complaints, staffing time to come to attend these meetings. And all it takes is for a one-sentence complaint, same exact complaint verbatim, change the date, and just submit 5 different ones the next time around. There's no guarantee that we're not going to be back here again. At the end of the day, the SOTF does need to come up with, make a determination and stick by it. The previous determination was that you guys found no violation with the exact same thing. So out of consistency, I would urge you guys to do the same. And again, seek administrative remedy through the city attorney's office, get consultation from them, or forward it to the ethics commission if necessary. So that's all.
All right, can I get this mic turned on? Is that okay? That one is.
Awesome. So could I ask you some question?
Yeah,
so
absolutely.
You just said that it takes a lot of time for you to come out here,
Absolutely.
and it's going to. So I mean, we could resolve this if the clerk just started putting them in the minutes.
Right.
I mean,
but again, she can't validate a third-party statement that, like, when it wasn't part of the proceedings.
But I mean,
So it is-
I'm really
I mean-
having a hard time getting my head around that since so many other committees don't have that objection.
They have had that objection,
But
but
I mean,
just
they-
tired of getting the same complaint over and over again.
But you guys, this is where you're drawing the line and putting your foot in the sand and gonna stick it out, and no
this
matter how
is-
many staff resources it takes.
This is exactly where we've drawn the line, because the addendum is part of the minutes. It is paginated as one singular document. If it wasn't one document, then essentially we'd be able to drop the addendum and omit it completely from the minutes.
Can you explain that to
were
me some
push-
more? Can you explain that to me some more? Why why you can insert the names of people in there with the brief summary that the clerk writes, but you can't insert a paragraph in there?
Why?
Yeah, I just don't understand. Can you spell it out for me?
Because the clerk doesn't validate that 150-word statement that's submitted.
But what does validate in that regard mean?
Meaning those 150 words were not actually what happened during the proceedings. They were submitted after the fact.
So what does validation mean?
So she's required by Admin Code 67.16 to record all the actions that happened, all the names of the speaker, whether they were in favor or opposed. She doesn't need to document it verbatim, but the 150-word statement is to supplement public speakers who either don't have the ability to speak clearly or iterate themselves clearly verbally. It just provides another means for them to provide their comment in a written format. Now, that doesn't actually happen during the board meeting, during the proceedings. Like, they submit it after the fact. And the clerk doesn't know what those statements are. It could be completely different from what statements were made during public comment, and she would have no way of knowing.
Through the chair, if I could follow up Member Mass's question. One of the things that the charter is predicated on is a reasonably intelligent person's reading of X, Y, and Z. Mm-hmm. I think minutes of city departments is part of the spirit of the charter. I think for a reasonably intelligent person to be able to see that John Smith got up and said X, Y, Z, then a statement followed saying, here is his 150-word summary, which he handed in right after he spoke. You're making it sound like these are two unconnected things. And a comment right there by the clerk saying, this is what they handed in and we take no responsibility for this, is not much to ask for. And other departments do that. That in a nutshell is what we're asking for. Because we think, and I've said this in the past, I think at previous meetings, that that's the spirit of what we're expecting. Now, the line in the sand, great. I think one thing I am going to recommend is that Ms. Cavillo come to the full task force meeting and tell us why that little adoption can't be made. She might have some very good reasons, but I'm sorry, I haven't heard it from you. I haven't heard it from the DCAs. It just doesn't seem reasonable. And come with her if you like, but if she would take the time, and I believe she was invited back in 2013 and deigned not to show. I could be wrong about that. We can check the records. But I think part of our recommendation to the full task force would be an invitation to Ms. Calvillo, who I believe is an I think she's a part of this body anyway, is she not?
She's an ex officio member.
There you go. Maybe it's high time she attended one of our meetings, either on this side or that side. Anyhow, I think it would be nice to hear it from her mouth why she wants to draw that line in the sand. Because a lot of this could be sorted out by her telling us exactly what it is,
Okay. Now, if I may respond to that?
Sure.
Now, if I may ask you guys to look at the two memos that were submitted in response to those complaints, the one that was submitted back in 2013, as well as the most recent one, addressing the exact same issue. Both of them were prepared by Clerk of the Board Angela Calvillo. That reiterates, that expresses in detail every single argument that she has as to why she opposes this.
And where is that in our package?
I don't have the full packet in front of me, but so I don't have the page numbers, but it is contained as part of our submission.
Give us a moment. The clerk can bring it up.
Sure.
23, 4, and 5.
23, 4, and 5?
There was one memo dated September 28, 2016, and
And-
another memo dated November 4th, 2013.
Were those page numbers from the first or second item?
1, 2, 3 was for the 2014. I'm sorry, 2000.
They would be part of both packets, but if you start with page 120, you'll see the September 28, 2016.
So that's
And then-
item 6.
On page 123, you'll see the November 4th, 2013 memo.
So we're back to item 6, right?
It's the same memo for both.
But they start on
files.
different pages?
Yes.
Yeah, okay, so we're back on item 6, page 120,
126.
126.
I believe it's 120 through 123.
Oh, 120.
Yeah, and both of those memos are incredibly detailed and tell way more than I've told you guys today.
And while we're catching up on that, Mr. Ng, can you tell us, maybe from your recollection, or maybe the clerk can tell us, the two that went to the Ethics Commission, was that to do with the clerk of the board, or was that another department?
That was another department.
Do you know which departments?
It was a Library Commission.
Both of them?
Library Commission and Luis Herrera.
Okay.
No, one was the Ethics Commission, one was the Library Commission.
Oh, I see. Interesting. Okay. And that should be part of the history on this.
And both of those are referenced in the November 4th, 2013 memo. And if you look at the very end of the memo, in the appendix, it references the two Ethics Commission complaints.
The appendix.
Which is part of the same document.
While we're looking at this, in this day of online indexing, it's pretty easy to have meetings where you have index, public comment. It's a whole section, and you can go to that whole section and go through it, look at all 150 word summaries all in one section if you want, then come back to item number 4. Look at that. I mean that kind of organization is possible.
Okay. We'll bring that up to Granicus Legistar.
Yeah. Mr. Hartz, I'll let him respond on that. Sure.
That was something that was argued at one point in time, and what they did is they went on their index, they went on the website, and the only way that the addendum ever showed up was if you knew that the word addendum was in there was a number 1, and if you knew that the number 1 was in blue and you clicked on it, the addendum would show.
Right.
If you didn't click on it, it wasn't seen.
Right. Now I'm talking about something much more, again, I'm not sure how much purview we have to tell them how to, set up their web pages, but where you could have, everything clickable, and you could read it from beginning to end. You could read sections, which would then expand out to have those pieces in it, etc. The technology is there to make this doable.
But the bottom line is, in each case, it makes it an extra step that the public has to take to see the comment, and the more likely that at least some people will not click and see the comment. And that's really why they don't want to put it in the body. Because if it's in the body, if you read the minutes, you're going to read the comment.
Yeah, unfortunately, our charter just says in the minutes. That's all that 6716 says. Now, I think maybe down the road, if we change that to be more specific, given modern IT and technology, and put some tighter language in there, that might be where we end up. So we could go through this whole beehive again, and in the end, based on the letter of the law, it just says in the minutes, and they're claiming the addendum is part of the minutes, therefore it's in the minutes. And that might have been where we ended up, on these cases, legally, to the letter of the law.
And again, because the full task force has voted to find violation, but then not voted to find violation, not saying that they didn't was one, but there was a vote not to find violation. And because of the differencing of opinions between this task force and the Ethics Commission, I think that the full Sunshine Task Force should reset a precedent on this, on what we're going to do every time we get this issue. And from that point on, if the facts are clear, the decisions by this body, the full task force, should be the same for every one of them.
If it's the same, I agree.
Right.
And Mr. Ng, just so you know, one of the things that we're trying to change is if we find violations at a department, to a certain department, and they've been fixed and demonstrated the fact that's happened, if then a respondent brings up the same violation that predated that, we may not hear that. That's something that we're talking about that'll become, policy or not in the future. That's not quite what you said about future ones, because, did you understand that?
Yeah, I completely understand it. But again, I may be beating a dead horse here. But there was a previous determination by SOTF made
right.
that there was no violation.
But you have to appreciate if the body has found violations and had ordered determinations against different departments, we should be consistent. So at the very least, I think the full task force should look at this issue, rule again whether it's your department or another department, and just say, this is what we found consistently, here's all the case law supporting it, all the work we've done in committee, supporting this is our position. And if that position is indeed, that we think it should be, right where the comments took place, as we have found in certain cases, then, the eye of Sauron is on you again. So it's not, we're done with it. You may have to come before us. You may have to answer, right, even though you've written some nice memos here, and we may ask to see Ms. Calvillo here, ultimately, to make this go much quicker. So that's just my position.
I just want to say that as a legislative branch of government, we are required to follow the letter of the law. So even we completely appreciate the SOTF's issuance of a determination, whatever it may be. At the end of the day, we do need to speak with our city attorney's office. We need to follow the letter of the law, and I'll be glad to relay your message to Ms. Calvillo to see if she's available to attend to the next one. But,
as ex officio or whatever, she's always welcome to.
Sure.
Okay. So I think this is going to be one that our lawyers are going to have to. The lawyers in our group are going to have to really get down to the nitty-gritty. And the more summary we can provide so they can get straight to the points would be useful. So.
Yeah, I think everything we asked for the prior item is the same. Is the same thing for this item as
Would you
Mr.
like to make duplicate the motion for this item?
No, but Member Highland was talking about this motion involving.
Well, this is a slightly different motion where Mr. Hart is talking about willful violation. Mm-hmm. That's a more serious. So I think we should treat them separately and have a separate call on it. But I think the more I think about this, the more I would like to have Ms. Calvillo, who is really the point person on the other side of this, a request for her attendance at the full task force meeting. So a motion to recommend to the task force with no recommendation and an invitation to Ms. Calvillo would be the motion.
I second that motion.
Okay.
There are no members of the public in the room at this time. Would you like to make rebuttals?
Yes, please. Rebuttals, the respondent, please. Anything else to say?
No, I think I've said my piece already. Thank you.
Thank you. Mr. Hartz.
I'll be honest with you, I get really confused by the fact that you've issued, this body, the full task force, has issued a memo to all city departments stating that in the minutes means in the body of the minutes. And you seem to be kind of willfully ignoring that. And they also sent a letter to the city attorney explaining all the reasons. He has never responded to that. The clerk of the board has had 4 years, this is the 2012 finding, to come up and go to the city attorney's office and get a legal opinion. She has failed to do that. The task force has ruled again and again and again and again and again and again and again, 7 times, to find violations. Sent out a memo to the departments 3 years ago saying what the task force had found. And now we seem to be arguing the same thing over again. And what credibility will this body have if you rule one way 7 times and then decide, oh, we got it wrong? There will be absolutely zero credibility left to the task force. And the bottom line is, and the reason this gets me so aggravated, is the fact that in the time, let's use the example of the Library Commission. The Library Commission was found in violation 3 times, and the last time they had a meeting of the Library Commission where they unanimously voted to ignore the ruling of the task force. They actually had a motion and voted on it. They never brought it up again, and yet in January of 2013, they started to put the 150-word summaries in the minutes. Same thing with the Ethics Commission. They don't want to have an actual discussion of the law because they know the law is not on their side. I guarantee you, if they could have done this, they would have done it sometime over the last 6 years. Is that an unreasonable argument? If the city attorney actually had law and precedent where he could say, putting these in would violate the law, here's the law. He himself was found in violation. His office was found in violation. I think if he had legal precedent, he would have presented it by now. And I think the old adage, silence gives consent, gives credibility to the idea that, hey, you ruled 7 times that it was a violation. And the fact that the task force got into a little pissing contest with itself, that on the 2013 relating to the clerk of the board isn't an issue.
Thank you.
I'd like to put these in the record because obviously I'm surprised these were not in the back.
Okay, vote on the motion.
On the motion, Member Highland.
Aye.
Highland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. The motion passes. Is anticipated this matter will be before the full task force on December the 7th, 2016. Notice will be sent to all parties once that agenda is finalized by Chair Wolf. I don't know if you want to consider asking the parties if they would like to have these items called together at the full task force, because it appears that it may be a consideration you might want to take up.
Yeah. Go ahead.
Through the chair, before that, I wanted to ask Mr. Hart something real quick. I think what would be really helpful for the full task force, and you're very good with putting up displays and whatnot, maybe come up with an example where you show the X department including the 150, and then showing how the clerk of the board doesn't include it. If you can get that on a, as part of the package, or better yet, on the projector, just to, because I think a picture be worth 1,000 words, just to see, how it just disappears as to where it should appear. I still think, after the words that were spoken, in the chronology that it was presented.
One thing I would make very clear, they talk about this, did he actually say what he wrote down? I read the 150-word summaries. And if I have extra time, I may add additional comments, but the main ideas that I want to get across in my 150-word summaries are in the 150-word summaries, and I read them literally. And as you mentioned, as soon as the clerk of the board, as soon as I'm done, I walk over to the rail and I hand it to one of her aides. So there is no, write something, say something and then write something else. It's exactly what I said. And you can, as you said, you can verify that by all the recordings.
Thank you. Also, through the chair, I was going to say, if you want me to take a stab at editing the draft of this that you send up, I'd be happy to do that, just to kind of give it the shape I think it should have. And I don't know if the three of us or just, who does that. And lastly, I will not be at the December 7th meeting, as you know. I'd very much like to be part of this, so I would vote to hear it later, but that might be, maybe we can put that in front of, see if they're okay with a month off. And then lastly, as far as hearing it together, I think because it's only 2 cases, and one talks, if I'm not mistaken, I think one includes Mr. Hart, so the first case does not include 6734, is that correct?
Correct.
And the second one does. I think that alone merits it being heard separately because there's 2 different levels there, I think. Yeah.
All right,
Okay.
good.
Next on the agenda, item number 8. Announcements, comments, questions, and future agenda items and pending calendar by members of the committee. If you look at the list that I have provided,
Thank you, Mr. Ng.
again, there is this older file, 14101. I do want to schedule this for the January meeting and ask that the parties come in and provide an update and close the file, and if the complaint still exists, they can refile at a later time. At the time of the filing, the requested documents did not exist. However, the committee at that time held it over until the program was finalized.
Sorry to interrupt. Can you refresh us a little bit on this one?
There's a program to track trees that is in development at, I believe, Department of Building Inspection. And as that program did not exist, there was no documents to give to the complainant. However, the committee at that time decided to hold it open until that program was completed. However, this has been pending for many, many years, and I do suggest that we close this out, and once the program is finalized, if there's still a complaint, they can refile.
What are we talking about? How many years back?
This is 2.5 years now.
And what was the complainant's first name?
David Grossman.
Okay. I vaguely remember this, but
It's just been sitting. I've asked for updates periodically, and my constant answer it may not ever be developed.
I see. Okay. Any communication from the complainant?
I have not received anything, so therefore I think we should schedule it and deal with it.
Okay.
Yeah, that's good.
We have the 2 reports that we discussed at our last meeting. I have been in contact with David German in DTIS, who will respond to both items. I believe that Member Moss is in the process of developing some questions to send to Mr. German for him to answer and report back to us on our January meeting.
Yes, for the record, I am nodding over here. I realized I was on audio, but yes. But just to sort of restate, since we're here, we had a few cases where out-of-office email responses had resulted in people not getting their IDRs handled on time. There seemed to be some issues where they couldn't produce a copy of the out-of-office email because it didn't save it in the sent box. And so we just wanted to discuss with Mr. German. Is it Mr. German? Is that what you said?
David German.
David German. Whether there is a way to address this in such a fashion that when these cases come before us, either they don't have to come before us because they've solved the problem on their end, or there is some sort of evidence trail that we can review when it comes up. Is that my recollection accurate or match with your guys's?
Yes.
Okay. And then for SB 272, I'll put together a few questions. My main questions, though, are going to be what kind of guidance has been given to departments, who's collecting these things, and one of the things that primarily concerns me is that SB 272 has a series of categories of information that are required to be disclosed per government enterprise system. And two of the, probably to me, the 2 most interesting items are the purpose of the system and the types of data that are collected. And what the City and County of San Francisco has done is to combine both of those fields into a single field and then barely put any information in them. So you would expect with other cities, you go and look and you see maybe a whole paragraph describing what the system is, and then you maybe see a second paragraph describing what kinds of data are collected. In this case with San Francisco, we get 3-4 words to answer both questions. And so that is what I want to ask them about as well.
Okay.
So that's basically it.
And the last item on the list is file 16071. That was scheduled to be on today's agenda. However, Mr. Borden was out of town, so we postponed it to our next meeting. And I believe the order of determination is regarding justification with withholding, and for the department to provide that justification as to why they withheld certain information.
Okay.
And those 4 items will be on the next agenda, along with any other items sent to the compliance and amendments at the December meeting.
Right. Thank you. Any other,
Public comment on that, or announcements.
any announcements? Public comment on this item?
Ray Hartz, Director, San Francisco Open Government. I find it really troubling that a complaint which is over 2 years old is still an outstanding complaint. I myself have been unfortunately caught in the bad place. I think all 3 of you were present at the point where I tried to say this is an additional violation and talked about a complaint that was about 14 months old. And Chair Wolf said, well, I don't want to open up a 14-month-old complaint. But what he failed to include there was the fact that it took 9 months from the order being issued till the Compliance and Amendments Committee heard it. And as a result, my talking about it was only talking about a complaint that had been settled 4 months prior. So if you're a complainant and you have a complaint that just drags on through no fault of your own, through a scheduling of the task force or the hearings of the task force or whatever, you shouldn't be penalized for that. That's not your fault. In fact, the law says you're supposed to have these hearings within 45 days of the complaint. And not having the hearing within 45 days, and then after the order is issued, letting it go another 9 months before it comes to this body is, I think, one that really should concern this body itself. If you're going to handle the enforcement of determinations by the task force, it has to be done on a timely basis or it loses its meaning. And the second thing is, and we've seen this over and over and over again, where you're sitting having discussions and people are trying to figure out, oh, do you remember what happened a year and a half ago? And people are going, oh, well, I think this happened or I think that happened. And in fact, in the previous case, that's what we had. Something happened in 2013, and now we're having a discussion about it now, although it has absolutely nothing to do with the issue. As far as the email response is concerned, I don't know. My attitude is that the same things go for the public as should go for the agency. If your director of your agency phones your phone or sends you an email and the response they get back is you're out of the office, I don't think they would be too happy with that. Although they might catch it and they might then go to your supervisor and say, oh, well, I can't wait till the person gets back. They're not going to settle for it. So the idea that somebody could say, well, we didn't respond because our email server isn't an acceptable response. The law is that it be responded, and the law, I believe, also stipulates that if somebody is out, somebody else is supposed to be assigned those duties.
Thank you.
No action is needed on this matter.
Right.
Next on the agenda is adjournment.
Motion to adjourn.
Second.